Anybody who misses part can revisit and watch the recording. So welcome to the 12th session of the monthly webinar series. We call it ETS for Policy Practitioners. It's hosted by the International Carbon Action Partnership, known as ICAP, and it's supported by the European Commission. And three partners implemented: Ecologic Institute, Get2C, and ICF. I'm Michael Mealing. I'm Deputy Director of the MIT Center for Energy and Environmental Policy Research and a professor at the University of Strathclyde Law School in Glasgow. And I'm very pleased to be moderating today's webinar, which is titled Legal Implementation of Emissions Trading. I'll kick off with a few sort of introductory remarks to frame the topic. We'll then go to a poll, and then I'll introduce our stellar panel, and we'll have the actual substantive presentations. Quickly sort of on the topic. I'm a lawyer. I think all three of our, at least two other of our panelists, maybe all three, are lawyers as well. All three have certainly worked on the legal implementation of ETS in quite a lot of depth. And what we hear a lot sort of as lawyers working in the climate space is, hey, lawyers, lawyers come in when there's conflicts. They come in to tell us what's not possible to do. They kill the good ideas that economists and engineers, etc., have. And I always thought, well, really, that could be further from the truth. When you look at an ETS, for instance, just the creative task of setting up the legal and regulatory framework within which this ETS has to operate and cannot even come into existence without enshrining it in such a way and in such language that it's not immediately a train wreck from the outset because it's conflicting with all kinds of laws, the Constitution, different areas of laws, energy, environment, commerce, etc. So even from the outset, very, very important to have that legal dimension, that legal angle very robustly present. But far beyond just initially establishing the legal framework, very crucial also for the day-to-day operation. Say, making creative, ingenious contractual arrangements for complex carbon market transactions to balance the rights, the interests, the obligations of parties, and to ensure that there's an equitable distribution of risk between them. And of course, the carbon market, there's a lot of value being traded. Just last week, I think Refinitiv came out with their estimate of how much the carbon market was worth last year in 2021, and the figure was 850 plus billion US dollars transacted. That's pretty large. That's the largest value ever for the carbon market. So of course you will have conflicts, and you again need lawyers to represent the parties to a dispute. You need judges to find acceptable, equitable solutions. And all that, of course, is critical to underpin the stability and credibility of the system. So I think it's an important topic, and that also explains why we had a really nice registration turnout for this webinar. Let me maybe start with a few housekeeping remarks, how we're going to play this today. So we have, as I said, a really stellar panel, and I'll get to introducing them shortly. But first, sort of the process that we'll have for the webinar. It is being recorded, as I mentioned earlier, and the recording and presentation materials will be made available on the project website. You'll have that. You have that in the chat. Johnny kindly posted it just now. The session overall is 90 minutes, and sort of a bit over half of that will be presentations, but after that, we'll have a Q&A. And for that, I would really ask you, we obviously encourage and really look forward to your questions, to use the Q&A function. So if you look on your Zoom bar at the bottom, there is a Q&A button. Focus on that. Some people like to put stuff in the chat, but when you're balancing the Q&A, the chat, etc., some questions could get lost in the shuffle. So really the Q&A is the safer option to use. And I'll be selecting and narrating the questions to the panel. I'll get back to these instructions once we get there. Before we though kick off, one quick thing: we have a Mentimeter poll, one of the sort of recurring features of this webinar series is that we start with a little poll to kind of set the scene, also get a flavor of the audience and sort of the prior knowledge, and just raise a few of the questions that will be dealt with during the webinar. If you look in the chat, you will see in a moment a link to the poll. So Johnny's posting, and you can just click on that. The second link, which has sort of a combination of numbers, if you click on that, it'll take you to your browser straight to the right link. If you want to do it on your phone, you can just enter the menti.com and the code that's there, the 229-9137, and you'll see the first question. And that is, why does law matter in the context of emissions trading? I alluded to a few things before, but just let's see what people respond in the order of what you think is sort of priority. You can rank your answers. You don't have to answer all of them before you hit send. We wait a few moments because they are a bit complex. One has to think about them, but we'll start seeing results popping up, I'm sure, in a moment. Interesting. Definitely some flipping of top priorities. But it looks like it's like a US election. Surprises until the end. All right, I'll start interpreting because we'll move on. Don't spend too much time. We still have 2 more poll questions. And of course, we really also want to get to the actual meat of the webinar. So it seems like quite a few people, we have 30 responses right now. Quite a few people are, correctly saying that a big role of law is to ensure compliance with the ETS, to offer tools for enforcement, etc. Sanctions, penalties, all the way to potentially criminal sanctions. The second one right now is empowers the government to implement the ETS. So gives the government, executive agencies, EPA or some body like that, the ETS administrator, the power to intervene in the affairs of businesses, of individuals. Creates expectations and ensures predictability, absolutely, especially when it comes to the actual trading, the market. Safeguards basic rights and freedoms, maybe seems a bit abstract, but is very critical. If you look at the early history of the EU ETS, quite a lot of lawsuits because people at the ETS violated some basic rights of operators. And increasingly, we're also hearing sort of how human rights play into the carbon market, etc. On the other side, those who might be affected by not controlling pollution, and finally provides a way to resolve disputes, seemingly the least sort of important in this ranking, but trust me, for some lawyers, this is the day-to-day job essentially to work out disputes in the carbon market. Perfect. Let's go to the next question. Very importantly, multiple answers are possible. Which areas of law do you think are in some way affected by or relevant for emissions trading? And again, there's multiple answers possible. Let's just see what thoughts. And you don't worry if you don't fully know. Benjamin was asking me for what's tort law exactly. He knows what it is in German, but not in English. So if you don't know an area, just ignore it. Let's see. I'm curious to see what the. Johnny, can we reshare the Menti link because anybody who joined late wouldn't see the previous chat? Hi, Stephanie. Good point. Thank you. Thanks, Johnny. All right. So I think you're getting the picture that pretty much every area here is relevant, and we don't have to wait till then. In fact, criminal and tort law are as well. If you read sort of the trade publications, carbon policy, etc., it's always the gossip column. Not really. I mean, it's a serious thing. That there has been fraud, there has been money laundering, there has been tax fraud, cyber fraud, thefts, etc. in ETS, and criminal law is definitely an important tool to deal with that. And tort law, that arises if one party does something that creates damages, including monetary or financial damage to another party, and that other party wants to recover those damages. So again, a very common thing, very general, of course, in no way specific to ETS, but it does play a role in many disputes or conflicts. And let's go, thank you for answers here. Let's go to the last one, to the third poll question. And this is more sort of thinking about the process. We have a handful of ETS out there, 24 or so by now. Well, certainly quite a number of ETS, depends on how you count and if you count multi-jurisdictional separately or not. And each of those had to set up the legal, the regulatory framework to establish the ETS before it could even start, before it could even see trading. How many years do you think it takes on average to create this framework? And if, of course, you're familiar with an ETS, say in your own jurisdiction, you might have actually seen that. So feel free to focus on that personal experience as well. All right, it seems that nobody is optimistic thinking this can be done very quickly in 0.5 to 1 years. And that's true. I don't know of any ETS that's been that quick. you might have expected China to have the ability to move really, really fast once the decision comes from the top. But there too, it's taken many years to sort of roll out Lisa in the chat is pointing out Alberta was a quick one. Probably, I would suspect, because Lisa had a hand in it. So, but anyway, so it's true. Like with the EU ETS from 2000 green paper all the way to actual launching trading 2005, took about 3 to 4 years at least, and some other systems likewise. So I think they're in the middle between 2 to 5 years. That's absolutely spot on. Wonderful. So thanks very much for your answers. We can close the poll. This was helpful, I think, again, to set the scene. And now finally, I can move to introduce the panelists, which I've sort of already variously said is really a stellar panel. Maybe it's because I'm a lawyer and I'm just really excited, but I can tell you as a lawyer, this is a rare confluence of expertise we have in this webinar today. We have an introductory keynote first, and that's coming from Lisa DeMarco. She's now senior partner and CEO of Resilient LLP, which provides legal services around climate policy, carbon markets, and others. But I've known her for, well, I actually had to go back and think. Since 2005, Lisa, I think COP11 in Montreal, so in your country, in Canada. And I've always been amazed at the range of activities you've been engaged in, from advising subnational, so provinces in Canada, for instance, national governments on climate policy, design and implementation on emissions trading systems, but also well beyond, to helping shape international negotiations under the UNFCCC, and all the way to assisting private clients, say in structuring transactions, etc. There's very few people, I think, that have done such a breadth of legal activities in climate policy and emissions trading. And among some other accolades, she's been appointed a member of the Ontario Premier's Climate Change Advisory Panel, the Clean Energy Task Force, Climate Action Group, and she currently chairs the International Emissions Trading Association. So Lisa, it's really, really great to have you with us today. Thanks for joining us. And I'll quickly also introduce our two discussants who will follow on Lisa's introductory presentation. They'll share perspectives, slightly different perspectives from academic research and then from public policy and actual market participation as well. We have Sanja Bogojevic, who is a fellow and professor of law at Lady Margaret Hall in the Faculty of Law at the University of Oxford. And she essentially wrote one of the key books on legal aspects of emissions trading with her PhD thesis, I think it was, Sanja, before it got published by Hart Publishing, Emissions Trading Schemes, Market, States, and Law. It's a really thoughtful analysis of the complicated relationship between the abstract economic rationality of emissions trading and the deeply contextual nature of its legal implementation. And she got an award, the 2016 Niels Klim Prize for that. Thanks, Sanja. We look forward to your remarks. And finally, last but certainly not least, Victor Escalona, who is Associate Director for Climate Policy, Finance, and Carbon Markets Advisory at South Pole. South Pole is a leading carbon finance service provider and project developer. I'm sure many of you have come across them. Before 2020, however, he spent a number of years at the Mexican Ministry of the Environment and Natural Resources, so known as Semarnat, where his last position was coordinator of the Mexican National ETS. So again, I think we couldn't have a better set of discussants to guide us through today's questions and to address these various different angles and dimensions of legal implementation of ETS. Thanks to all three for joining us. And Lisa, I'll invite you to start by providing something of an introductory presentation. I think you have slides. The virtual floor is yours, Lisa.
Thank you so much, Michael. And first, let me heap accolades on Michael. It has been almost 20 years that we've known each other. And I have to say that whenever I'm noodling through an issue and it's sticky and it's got lots of legal tenets and tentacles and layers of that onion, I always think, what would Michael say about this? And often I'll pick up the phone and say, Michael, give me some good, meaty, detailed thought and, just an extraordinary talent. So extraordinary appreciation for you and everything you do in this space. I am going to try to share my screen and let's see how that works. And then pull up a PowerPoint presentation. Oops. Let's see if I can go to this. Are you seeing my screen?
Now something's coming. Yeah, and I think it's once you start the presentation, I think it'll be the right screen. Let's check.
There we go. So what I want to do just very briefly is give you some emissions trading basics, the basic elements that really do draw upon the law to give them life. look at where we're at with carbon pricing worldwide and just talk about some of the tenets of emissions trading that are continuing to give rise to new, novel, and actually quite traditional uses of the law, but in different ways. So we've talked through very briefly a cap and trade system or an emissions trading system that uses a cap and a broader series of limits. But we all know and are familiar with various carbon pricing systems that are theme and variations on some semblance of a baseline and credit system, some systems that use an auction that have limited allowances, some systems that provide a tax, that all have various elements of tradability in them. In particular, I would speak to the Canadian system, which is a combination of a carbon levy, not quite a tax. We went to the Supreme Court to call that a regulatory charge, not a tax, based on our constitutional division of powers. And also an element of a baseline and credit trading through an offset system available to large industrial emitters that fall within a threshold. These are all theme and variations, and what I'm very basically going to generalize as a cap and trade system right now, but note that I'm speaking of carbon pricing writ large. The basic element is that there is a notional limit on emissions, either through the imposition of a price or a cap. Michael knows, and I think we share this view, that I like to keep my eye on the ball, which is what are the emissions and are they going down? So my preference is a capped system, but equally effective are price systems throughout. And that fluctuates. Certainly the pricing associated with the cap fluctuates throughout the market. In there, we can see elements of border carbon adjustments. Is this just applying to my jurisdiction, or am I going to limit what comes into my jurisdiction and the emissions associated with it? Certainly, we're seeing this in Europe with the CBAM program. The US is talking about some form of border carbon adjustment, and Canada has a live proposal on the table as well. We have elements of constitutionality. Just because emissions are happening doesn't mean we can erase the constitutional authorities afforded to national governments and their subnational jurisdictions. So we often see ourselves tied up in legal cases, particularly in the US, around constitutionality, but they're not a stranger to that. In a number of jurisdictions in Europe, we've seen the constitutionality of systems or the lack of a system challenged. And in Canada, we had a fight over who has the jurisdiction, the provinces or the federal government. Increasingly, and if I'm going to make a prediction on this introductory seminar, it's in and around criminality and securities and commodities trading and financial disclosures. We have seen in the last 6 months an enormous growth in cryptocurrency tied to carbon credits, and very much in the realm of trading what I believe to be an unregulated security associated with carbon or some reference token to carbon. I don't think it's very long before the market changes there, and the harms in certain aspects of that market, which can be very, very beneficial, but used wrongly can cause great damage, come to the attention of consumer protection advocates and securities regulators to start getting very active in that regard. We certainly have financial disclosures becoming mandatory in a number of jurisdictions, the UK, Australia. Canada is currently contemplating mandatory financial disclosures in and around the Task Force for Climate-Related Financial Disclosures. Competition issues. This is also consumer protection associated with competition. Do we have antitrust issues associated with or arising from emissions trading system, particularly where there are groups of purchasers that are collaborating on often market sensitive or financially moving data or initiatives? national security issues. We're certainly seeing this in Eastern Europe right now. We had the IEA come forward and chat about the developments in the energy sector, particularly the transportation of natural gas from Russia into Eastern Europe. And the IEA has pronounced that that's not responding to normal market signals, with the inference being the energy and associated emissions market impacts are being used for purposes beyond their intended use. I will be careful in how I say that. And then finally, intellectual property and information technology. There is a host of data and metadata that is coming to bear both in emissions and in emissions reductions and in the related trading system. And Michael pointed to manipulation of some of that data and some of the taxation associated with it that resulted in some frauds early on in the EU ETS. We expect to see more of that IP-IT consideration come to bear with the proper and appropriate use of distributed ledger technologies and native tokens to facilitate access to global ledgers for both the emissions, our national inventory reports globally, biennial transparency reports under the Paris Agreement, and how we might digitize that. There's also challenges around the IP and IT about improper digitization of the units themselves and double counting or double claiming. So is this a small thing, and where are we at globally? I wanted to include this slide to really indicate that we do have close to 30% of the globe now covered by some form of a carbon pricing system. And that is increasing on almost a daily basis. Certainly the intent that was expressed at this year's COP by a number of supranational organizations, including the World Trade Organization, the IMF, the government of Sweden, the government of Canada, were all on a panel together talking about a shared goal of increasing coverage of carbon pricing systems to at least two-thirds of global emissions by 2030. And really from a predictability and certainty and business perspective, the greater the coverage, the better and more effective the system is. It's where we have disparate treatment that you create vacuums or gaps or disparities in the approach to climate change. So let's look at some of the areas of law where we see both public law and private law coming to bear. Michael's absolutely right. Tort law and criminal law are quite important. We've been involved in a number of those cases, and increasingly so, we're seeing youth litigants come to bear using all legal tools at their disposal to try and facilitate greater climate action. And that includes not just constitutional aspects or human rights aspects, but also tort law. From the public perspective, energy law, very, very important. We're seeing the integration of energy markets and climate markets. In New York, for example, the New York ISO and the public energy regulator are looking at integration of those two markets. So you actually have coordination of the dispatch curve, particularly of electricity, with its emissions weighting, not just price, but actually emissions. Administrative law. One of the key elements that we are regularly active on and involved in regulatory litigation around is the concept of audi alteram partem. Wouldn't be a legal presentation, Michael, unless I threw a little Latin in there. So audi alteram partem, everyone has the right to be heard. And this has been historically an issue with the old CDM executive board, where there wasn't an effective right of appeal. And that has essentially been remedied in the new rules under Article 6.4 of the Paris Agreement, which speaks to an appellate right under that supervisory body top-down mechanism for a sustainable development mechanism therein. Tax law, a lot of questions come across our desk, and a lot of questions come from my desk to our tax experts to answer basic things like, am I taxed at source for this emission allowance? And is the taxation on my trade of an emission allowance different than the treatment of the taxation on my trade of a voluntary offset within that scheme? And the answers are quite interesting, very dependent on a number of aspects, and they involve not just domestic taxation schemes, but tax treaties between jurisdictions. Let's move on to criminal law we talked about. There are some bad actors out there. And I do want to encourage countries and standards and standard providers to take some self-help measures in an attempt to avoid criminal conduct. So in particular, limiting what your units can be used for and how they are treated may go a long way to avoiding some of the behavior which has the ability to defraud or take advantage of those that are in most need of protections. The single-use purchaser, we don't have their international trade law, and we do have a few cases. Right now we have dispute resolution going on between a US voluntary purchaser that was induced into the Ontario emissions trading system and had its units effectively nationalized or expropriated by the Ontario government when it announced with no notice that it was pulling out of the Western Climate Initiative and not entering into an auction. So that dispute is playing out under the last vestiges of the North American Free Trade Agreement, which is now effectively replaced by the US, Mexico, Canada Free Trade Agreement. And we're watching that very carefully. There are also class actions around that domestically. And those class actions under private law take the form of challenging under basic concepts of property law and contract law and corporate law and accounting challenges as to how did you do this? Was this consistent with broadly the rule of law? And that is the overarching message that I'd like you to take home from this presentation. This system, these systems operate in the context of the rule of law. And when we deviate from the rule of law, their effectiveness, their utility in reaching the goals of global emission reductions consistent with the 1.5 degree target under the Paris Agreement is very limited. So the rule of law should be an umbrella that we operate under in all aspects of emissions trading and related carbon pricing. Very briefly, at the international plane, we did speak to some of the broader treaties, the UNFCCC, the Kyoto Protocol, the Paris Agreement to the UNFCCC, other climate cooperation regimes. We're seeing that develop. Other broad environmental regimes, we touched upon world trade law and the disputes thereunder, and then private international law. We're seeing actual transactions that are often governed by Incoterms or by dispute settlement processes that are international in nature, being affected by international emissions transactions that are either in and of their own accord, i.e. just about the emissions, or attached to products, such as net zero oil or net zero steel, or net zero minerals, or minerals with a lower carbon profile. And we expect more of that to come. And then supranational law, looking at primary law, those general principles that are ensconced in the rule of law, and the fundamental freedoms of individuals, particularly youth, and those that will have to deal with the problem as we age and go over that rainbow bridge. And then secondary law, looking at, in particular, I'll point out state aid and competition law. We see that as a growing area. And as the transition to a lower economy occurs, we expect the energy transition to be affected by that supranational law. So you can see this is pancaked on top of each other. It occurs at multi-levels and has to be considered in a gestalt, holistic basis as you both design emissions trading systems and operate them. We've talked about this multi-level system and the jurisdictions that may play into it. It isn't just national governments and international law. In fact, we see municipal bylaws related to climate change that must be respected as well. We see regional and state and provincial laws that are often more effective and more targeted at specific emissions that are incredibly important in that jurisdiction. I mentioned how quickly the Alberta emissions trading system was brought to bear, was up and running in 7 months. It's because those oil and gas and electricity emissions were incredibly important to the jurisdiction, and they had to regulate them immediately and get that system up and running in a meaningful way. So looking at the normative pyramid of law, how do we go about this in the context of designing an emissions trading system? Certainly we'll look at the constitutional elements of a specific jurisdiction in the broader context of the treaties, particularly the Paris Agreement that they've signed, and trade agreements. You'll look at specific parliamentary legislation. You'll look at executive rulemaking, regulations and ordinances and directives and orders, and often now permits are mandating emission elements to them. For example, leave to construct a pipeline or an electricity transmission system may in fact have as a condition of approval requisite number of emission offsets or a net zero type obligation. And then we'll look at administrative norms. How do you calculate this? Particularly for some of the allocation of emission instruments, it's very detailed. There are a number of formula and assumptions that go into, for example, how you allocate emission allowances to a cogeneration facility that is both using fossil fuel, but producing beneficial steam and reducing emissions. These are difficult administrative norms that need to be undertaken through technical rules and guidelines. And often there are memoranda of understanding that come to bear on how that's done. Certainly we see that in the Western Climate Initiative. So let's look at putting emissions trading in the law. And this is really effective in the context of your Mentimeter, Michael. I think the point is that it is a Venn diagram of intersecting and overlapping areas of law that are incredibly important to how we approach. And I love this diagram. This is a Michael Mealing original, and it really does focus and show just how interrelated these areas of the law are. And for us, we're considered a boutique, extremely specialized firm, but you can see in many ways we're extremely generalized and have to draw upon other experts who bring to bear specific expertise in discrete areas of law: securities, taxation, international dispute resolution, trade law. They all come to bear. So much like the parties to the Paris Agreement, we have to engage in cooperative approaches to really be effective in achieving the goals of a lower emissions planet. I won't take much more of your time. I just want to conclude on a couple elements of those aspects of the rule of law that I think make us effective and efficient in what we're all trying to do, the shared goals of the Paris Agreement. First and foremost, whenever we're designing and operating and implementing and settling arguments under emission trading systems or treaties or local laws relating to them, we go first to legality. What does the law say? And that's the what aspect. And then we look at how. How was this done? How should it be done? What are the processes, the duration, the participants, the process around how we obtain certain elements or instruments and how we use them? Are they legitimate? Is this transparent? Is this replicable and certain and predictable in a manner that's consistent with the rule of law? And that goes to the associated flexibility. You don't want to stifle innovation, both in terms of how that law is applied and how the systems might operate to scope and scale the emission reductions to encourage ambition. And that's really the point in facilitating emissions trading, is getting more emission reductions faster. So integrity and ambition is often facilitated by flexibility. So looking at teasing out, for example, in the digital ledger technology world, how we can use this beneficial technology without compromising the legal integrity of the system. And finally, resilience, looking at judicial resilience, how the law is applied, how the systems are upheld, and how they can be effectively insulated from what we call colloquially the stroke of the pen risk. When we get the politicization of emissions trading and carbon pricing, we all suffer from it. And there's a parallel there in relation to the pandemic. We all have to keep our eyes focused on the end goal, and that is security and safety and the resilience of the planet and the people who live in it. So those are just a few elements, and I'm really looking forward to the talented legal minds that are with you today, so I can learn from them and continue our journey of cooperative approaches and learning in this space. Thanks so much, Michael.
Hey, Lisa, thank you very much. I really think you gave us a wonderful tour through the way that an emissions trading system is situated in this complex, how could I say, universe of the law, and all those multiple interactions, but also some of the principles that can guide our understanding of the legal implementation of an ETS and how to do so well. And what I particularly enjoyed, on pretty much every question, you can always find an anecdote from your own work that links to a practical example, to something you've done in the past, which is awesome. I'll hand over, if you can unshare the screen. I think Sanya will also have some slides. So I'll hand over to Sanya. She'll be sharing some remarks, reacting to Lisa, but also adding her own thoughts based on her many years of work on emissions trading from an academic researcher perspective. Sanya, over to you.
Thank you so much. So in fact, I don't have slides, so it is only my office and I at the moment. But so 2005 seems to be a year that is important for this discussion. So it's the year that we understand Lisa and Michael met. It is also the year that I started researching ETS. And I thought that I would by now have left ETS behind long and well, but it really is a subject that keeps giving. And there is There are so many fascinating aspects of ETS, and that really goes to Lisa's discussion, but also Michael's introduction, that there are so many different layers of law that are relevant to ETS that makes really this subject 20 years later still interesting to explore. So I'll start by thanking Michael for the invitation. It's great to be here virtually, and also thanking Lisa for the superb talk. And it is particularly refreshing, I have to say, to in debating ETS to focus on the law. So after all, carbon markets are legal constructions, and this may seem obvious to the audience today. And I will look at the related point, and perhaps more pertinent today, is to think about, law is relevant, but what role does it play? And in this regard, I will make 3 points. So the first point is that we have a broad range of choices in how we construct ETS. So one choice that policymakers need to make is determining the scope of the carbon market. So if we take the EU ETS as an example, and Michael has already alluded to this example. So when it was set up, it covered installations in the steel sector, together with the list of other industries as annexed in the initial directive. It didn't, however, cover installations in the chemical sector, for example, or the so-called non-ferrous metal sector. So is that then a problem? Where Arcelor, the world's leading steel company, sure thought so. So it challenged the ETS directive before the national and then the EU court, claiming the laws are discriminatory and should be annulled, the ETS law. So the court agreed that in determining the scope, the EU regulators had treated certain sectors, including the sector that Arcelor was in, differently from others. But it found that the ETS directive is still compatible with fundamental principles, and it argued that the ETS is a novel and a complex scheme whose implementation and functioning would have been disturbed by involving too many participants. And it said that in view of the novelty and the complexity of this scheme, so-called step-by-step approach was legitimate, and that it didn't disturb the, and that it was allowed under the discretion that the EU legislator enjoyed. So legislators have similarly had choices to make, whether to include, for example, aviation. Again, if we stick with the EU context, this led to a very controversial case that was led by the EU's aviation industry, who argued that the EU legislator could, should it decide, include domestic flights in the EU ETS, but it couldn't extend the invitation to aviation outside of its jurisdiction. Or flights outside of its jurisdiction. So this obviously led to important debates within the EU of how then to include national aviation without, however, causing it a competitive disadvantage against non-EU airlines. What this means, and this is my second point, and it's really building on what Lisa has already said, is that these choices in how ETS is regulated, they're really not straightforward. If I've just given you the example of the scope, but if we look at how the cap is set, if we look at how allocation is carried out, if we look at how enforcement is secured, if we look at how allowances or permits are legally defined, these are all difficult questions for policymakers to make, and there are no uniform answers as to what the right choice is for all in one. So inevitably, the choices are made with some industry players feeling like losers, Arcelor being the case in point, and others feeling probably like winners by not being regulated. It also shows that the example that I'm giving is that institutions matter. Here, the EU court has been fundamentally important in adjudicating and stabilizing the conflicts that have been caused by the various regulatory choices, and coming back to Lisa's point, ensuring that the rule of law is upheld. So my third and final point, and linking to what I've already said, is that decisions that we end up taking in constructing carbon markets will inevitably depend on what role we give emissions trading and how we understand it as a regulatory strategy. A recent and ongoing debate in the UK, where I'm based, but also elsewhere, is that in terms of carbon market construction, should we include emission permits derived not from emission reductions, which is the current setup in the EU, but also from removals, which would derive from so-called greenhouse gas removal projects? Why does this matter, and whether they should be included or not? The answer is that it goes to the idea of, well, what is the purpose of an ETS? If it is to change behavior, then perhaps so-called remissions from removals should not be included, because this behavior of industries is not necessarily changed. But if it's really about dealing with greenhouse gases and climate change, then perhaps they should. And this is not a straightforward discussion. So this may seem an abstract dilemma, but it really is not. So if we return to the EU ETS, again, as an example. So as a part of the EU's Green Deal, the EU has said that it will use the EU ETS to fund parts of the 750 billion recovery plan, that is in euros, by extending the scheme's scope and making good use of the revenues from auctioning of emission allowances. So it would use the auctioning funds to fund the so-called Green Deal or the pandemic recovery plan. So if we look back at the history of the EU ETS, this may seem as an appropriate role for this particular regulatory system to play. After all, it was introduced back in 2003 and when it was set up in 2005 with the promise of advancing the EU's position in a so-called global race for green growth and jobs, and secure a so-called win-win regulatory scenario where environmental law would help stimulate the economy. Once the ETS was established, however, judicial battles emerged as to what purpose it had. Was it primarily an environmental mechanism aimed to reduce greenhouse emissions? Or was it principally an economic stimulus dependent on high carbon prices for its sustainability? Deciding between the two interpretations had consequences for how the mechanism was constructed and managed, and how well it aligned with the constitutional setting of the EU. And this is the point that Lisa also made. So this is to say that the law plays a fundamental role in constructing and managing the ETS. How we construct and manage carbon markets is ultimately a policymaker's decision, and it's not an easy one. But the law is there to allow policymakers to be imaginative in its ambitions in this regard. So those are my comments, and I would be really pleased to re-engage with Lisa later on to talk about these various roles that law is allowed to play. Thank you so much.
Fantastic, Sanja. Thank you for that as well. I think, you know, we're really weaving a nice tapestry of or narrative on our topic today. As you were speaking about this sort of tension between avoiding or reducing emissions and having emission removals, you know, the common thinking is that an ETS by 2050 can only be about removals because all avoidable emissions have been brought down to zero. Now you have to sort of neutralize the remaining pockets of emissions. And this shows you how science interplays with the regulatory and policy issues. Just last week, a new scientific publication in Nature Climate Change, I just had to bring it up because I feel it's such a nice example of how policymakers, lawyers have to pay attention to climate science, proved that given the nonlinear sensitivity of the climate system to emissions, an avoided emission is actually worth a lot more in reducing global warming than a subsequently removed emission. So, you know, interesting interplays between legal science, policy making, and then climate science. Johnny reminds us, and I would certainly encourage anybody who has questions already, feel free to enter them in the Q&A because they'll be waiting there for the moment that we kick off with the interaction with the audience, while we have our final, but certainly not least, discussant, namely Victor Escalona, who can reflect on both his current work in the carbon market, in making it, operationalizing it in practice, but also, of course, setting up one of the newer emissions trading systems in the world, namely the Mexico. And Victor, thanks for joining, and over to you.
Thank you very much, Michael, for the invitation. Thank you to Ecologic and to ICAP, which I hold really deeply in my heart. Actually, I have a long history. I myself, I'm an ICAP alumni, and I got the chance to work together with Michael when we were setting up the ETS in Mexico. He helped us with a really great assessment on a policy mix options that we had back then. So it's an honor for me to be able to participate here today, and thank you to Lisa as well for such a comprehensive introduction, and to Sania to cover these questions that we asked ourselves back then when I was working in the government, and that we also try to answer for others now in my position at South Pole. So I have a couple of slides. Let me share my screen with you. Let me know when you can see it.
It's coming, I think. Yeah, there we go.
Perfect. So my presentation, or my slides today, cover a little bit of the background of the Mexico ETS case, and then what's coming for this system for the years to come. So I call this period concept to implementation, because it goes a little couple of years behind when the first climate change law was approved in Mexico, which was in 2012. It was the first in Latin America. I believe it was the second in the world, just after the British one. It established climate change policy and created obligations to large emitters. Then, as both Michael and Lisa have mentioned, energy law, it's quite important when setting up an ETS. In this case, it provided a lot of foundation for later regulation when it was approved, a new electricity law in 2014, and then derived from the climate change law. Very important also to define the scope, as Sania mentioned. A greenhouse gas reporting regulation came from the climate change law. So these first two laws, which derive from constitutional reforms, the first one in 2012, the climate change law, created an option for the Ministry of Environment to implement a voluntary carbon market, which, as everyone knows, in this case, it's really hard for a government to set this kind of schemes if not with the proper regulation. So in this case, it didn't went beyond an intention to regulate. It only kept operating under the Kyoto Protocol and CDM projects. But something that really important came from this law, and was the specific regulation or secondary regulation that created a mandatory greenhouse reporting regulation for scope 1 and 2 emissions for large emitters and for also consumption and transportation emitters. The other law that I mentioned, the electricity law, was approved in 2014. It establishes that all the participants in this industry, including power generators, had to meet some emission reduction obligations once the Minister of Environment set these obligations. But also it included in an article that I think everyone forgot about when it was approved, is the obligation for all the electricity industry participants to participate in market mechanism in case the environmental authorities decided to establish one. It was even before an ETS was discussed in the climate change law, but it already created or it already considered power generators as key participants in a market mechanism. So it laid out and it created a lot of good arguments for us at the Ministry of Environment back then to bring on board all the power generators in Mexico. So there were a lot of challenges back then, mainly finding the right option, the right regulation option for implementing an ETS. There was a lot of capacity building needs back then, which were covered in many different ways, which I'll mention a little bit in the next slide. Of course, the challenge to finance the project, you have to have the money and the resources allocated properly in order to be able to make all the analysis and to hire all the experts that you need to actually be able to adopt such an instrument. And of course, the opposition from the industry, which is not always happy to participate in this kind of systems. But then it came the Paris Agreement, and Mexico committed to economy-wide targets. The difference here with the first climate change law is that these targets were not aspirational, were not only a good intention. It actually created the commitment to reduce emissions. So it created the need to update the regulatory framework, including the law. So among the many amendments that happened in 2018, the most important one was a change in the article that created this option for the Minister of Environment to implement a voluntary carbon market. It actually created the obligation for the Minister of Environment to implement an emissions trading system, considering the participant sector's inputs. This was really important because, of course, there was a lot of lobby during the process, but I think in a good way, because it created this aspect that also Lisa mentioned of legitimacy and transparency during the design process. So what these amendments also mention is that the system should start with a 3-year pilot phase for capacity building purposes and with no economic impacts, which mean 100% free allocation during these 3 years. And our next phase could happen after the pilot. So the ETS regulation came 1 year later, one and a half year later, covering industry, oil and gas, and power generation. Having the information from the reporting system from 2014, it made sense to include in the scope these sectors and target with a threshold of over 100,000 tons, which covered around 300 facilities and around 45% of Mexico emissions. It also created the compliance period. In this case, were yearly compliance periods. And it also mentioned flexibility mechanisms, including offsets. Though pending specific regulation is still an issue. There hasn't been any offset development for this specific purpose in Mexico. So among the challenges was obviously the discussion process prior to the approval of the law. To engage with all the stakeholders, including the industry. It's not always easy to bring them all on board for a meeting. And of course, the timeline, it was a tight timeline for the implementation. But among the achievements was, of course, having the law amendments approved, the regulation approved, to have a stakeholder engagement and a consensus among the majority or among all of them for an ETS. And capacity building, and this includes all the support that we received from ICAP, from consultants from the World Bank, with support from many different development agencies, including GIZ, for example, that supported this process and that created a lot of knowledge internally, which I feel very proud of. And now, what is happening with the pilot? in the future for the next phase of the ETS in Mexico. So it needs to happen a transition towards a full operational market, and we have a pilot phase dominated by COVID-related delays. Of course, everything got impacted. Participation and compliance results, for example, are not available for public consultation. In the regulation, it says that the pilot should be evaluated, and with these results, it is supposed to be or is supposed to help a new regulation that should regulate the next phase. And one thing that impacted this pilot a lot in the last couple of years is that no additional resources were allocated to the operator, and this is the Ministry of Environment. So it had to operate the ETS with existing resources and constant budget issues in its operation. So for a full operational phase, and now this is the consultant talking, there has to happen a lot besides just an analysis of the pilot and just write a new regulation. Several things need to happen as well. Financial regulation needs to be updated to allow trade and auctions of this kind of instrument, of this new commodity, which is not allowed at the moment. There needs to be regulation, at least at some degree, defining the legal nature of allowances. And of course, the pending offset regulation is a must if all the projects that are in the pipeline have at least an opportunity to exist, or an opportunity to be able to trade their current activities. There needs to be the secondary regulation, these technical guidelines to define the methodologies, which kind of activities are going to be accepted. And for the future operational phase, challenges, well, obviously, political problems are always present at different levels. Climate change is obviously not a priority right now for Mexico's policies, and you see this in the new energy policy and energy reforms that are scheduled to be approved. There's a little bit of loss of interest from participants due to delays, due to lack of pending regulation. We have detected in our clients a little bit of loss of interest in this case. There's of course unclear outcomes from the pilot, since we don't have available results or compliance results. We don't have at what level the participants were able to comply with their obligations in the pilot, and we don't have an evaluation results to be able to analyze or to make a deeper assessment on this. And what I already mentioned, pending secondary regulation, it would be a challenge because there's a lot of stakeholders involved trying to get their projects eligible for this system. And there's need to be discussions with the Minister of Finance and with other financial authorities in order to be able to have auctions, and in order to be able to use that revenue towards climate change issues, or even the operation of the system. One thing important is that many of these pending regulation at the time were not possible to include in one single regulation, which is pretty common to have one single regulation for everything. In this case, it was due time issues, so it was delayed and put later on for the offset regulation to come, and obviously the pilot phase was also supposed to help for this additional regulation, include a financial one, to give time to authorities to be able to approve it, and for stakeholders to actually understand the system and be able to understand it well and then participate well in a full operational one. So this is a little bit of the background of the Mexican ETS, how the pilot was implemented, and what are the challenges for the future in terms of regulation. Thank you.
Muchas gracias, Victor. I remember vividly how we were discussing, when was it, 2015, 16, interpreting that one provision in the general law on climate change and what does it mean, mandatory, not mandatory, etc.
Exactly.
And you laugh, I'm working with Indonesians now, and they have a mandate in some legislation as well. And it's the same thing, again, unclear, you know, what kind of mandatory, voluntary, which coverage, etc. I really like how, you know, it may have seemed like these were sort of three very different presentations, but if you go back to the Mentimeter, you can sort of see there is a logic there. Sanya and Lisa both spoke to the role of law in making an ETS, why it's important to think about law, what sort of the basic fundamental role of it is. And Lisa in particular then showed how it's interwoven and interdependent with so many different areas of law. And then the final Mentimeter slide was about how long it takes to set up the ETS. And that's really what Victor now took us through step by step, highlighting the challenges and the achievements, etc. So for me, we've sort of really closed the circle. I'm very happy, and I hope the participants also have seen sort of the logic here. We have a number of questions already popping up in the Q&A, and I'll get to them in a second, but I always like to offer an opportunity for the panelists to react if there's anything from another panelist's presentation or remarks that they'd like to comment on. So this is entirely open. Victor, Sanya, Lisa, any of you want to say anything? If not, I'll go to the Q&A. Sounds like you're ready to tackle questions from the audience. All right, so I'll check they come in sort of chronologically, although I will highlight there's a chance to also upvote if anybody wants to really make sure that a question goes up in the stack, goes to the top of the list. The first one that was put in was a kind of specific one, but I happen to know that Lisa just recently took on yet another responsibility. You're chairing an initiative to bring some transparency to this burgeoning market that you mentioned on introducing, tokenized crypto carbon assets. And I agree with you, when you see suddenly a transaction with one offset for $70,000, you wonder, is this going to go well? Is this a good or a bad thing? And Fawaz Abu Ghazaleh asks, how can technology companies that are developing DLT, so distributed ledger technology solutions, participate in the implementation of ETS? It's not directly at Lisa, I think all, of course, can weigh in, but I do happen to know that Lisa's thinking about this very much lately. Any of you, any thoughts on this?
Yeah, I can speak to my thoughts originated in fear, and in the process of seeing some bad behavior of the markets, I've been really educated, continue to be educated by entities like the World Bank and a number of countries that have adopted distributed ledger technology to facilitate the actual reporting and automation, digitization of exactly the amount of transparency and predictability and veracity in the data that goes up to the Paris Agreement in the form of the initial report on Article 6 activity, on the national inventory reports, which are required annually, on the biennial transparency reports. You can actually use DLT to upload the data. Some of it's automatic, actually, for meters in certain installations, to create and multinodally verify the data that would go into those reports. And that's where I think there's great strength in using DLT technology, distributed ledger technology, to really facilitate both the compliance with the Paris Agreement, but in particular the transparency and the accessibility of the reporting. Capacity building in the G77 around reporting in particular, and getting the data up and out is not a small task. Even not within the G77, there is a huge amount of work that needs to be done in that regard. So this is a way to really use developing technology to both increase accessibility to good and open source and transparent data, and also avoid mistakes in certain instances. The flip side is when we get into different approaches to tokenization, I'm given to understand there are 3 types of tokenization. when you go beyond the native token, i.e. the carbon unit as a token, and create what are now known as reference tokens or zombie tokens, or a security interest in a token without having the appropriate regulation to ensure that there's no double counting, no double claiming, no double use, and that there is no unconscionability, that legal term, that you're not taking advantage of disparate positions in the marketplace and knowledge and power. It can be problematic. And Michael mentioned, we've seen some interesting behavior in the marketplace where tokens are sold at X amount, many thousands of dollars, and when they go to be redeemed, they're valueless. And that has concerns raised for me on the consumer protection side. But I don't want to outweigh the real opportunities that we see for actually using that data in a way to scope and scale the Paris Agreement writ large. So huge opportunities there. And let me couch everything where I am a neophyte. I am not an expert. I am learning. So. I think we have Michael frozen there. Oh, there we go.
No, I'm back. It happens every week or so. There's like a few seconds. Sorry, that's the price for living in where I am, surrounded by snow in a remote part of New York State. Yeah, Lisa, I think you can relate. Did Sanya or Victor, did you want to weigh in? I mean, this is an exciting, and as much as it's sort of a daunting and a bit anxiety-inducing, but it's also a very exciting frontier of carbon markets, more probably in the voluntary carbon market space, more in the crediting space, but still, I imagine that South Pole is also active in one way or another in that market.
Definitely, Michael. Basically, what we have analyzed first was the use of the technology itself, for example, of blockchain for registries, and we provided some assessment and some of the pathways that some of our clients could follow in order to adopt this kind of new registries or registries using blockchain, which provide advantages and disadvantages as with every technology. It provides a higher level of transparency, but a lower degree of control for the authority that is implementing this kind of instrument, right? And that's something that some authorities are more willing to give up this type of control than others. So it depends on the country, it depends on the authority, and also on the culture of the people operating there. Some people tend to hold more control over some kind of assets than others, right? Some of them are more willing to do it and to prefer transparency. Another type is this green tokenization of some assets, which is still a new topic for us, and we have explored some options, though nothing concrete yet that I could talk to.
Mm-hmm.
Yeah,
great, thanks.
A very
Sanya, please.
Yeah, a brief point on that. There is also from the academic community. So Justin McInerney, he's a postdoc at Edinburgh. He's written a really fascinating book on blockchain and how it can possibly facilitate the workability of ETS, and in particular with regards to linking, because that has always been an issue and it's not straightforward. And I think that is definitely something that, and here I would very much agree with what Lisa has already said. It obviously has the potentials that have already been outlined, but again, we will still need the law to lay out who are participants, what are the implications, the liability, how is the security being carried out. So it doesn't, it can possibly facilitate, but it doesn't do away with the legal questions that are still relevant in making sure that ETS operates in a functioning functioning manner.
Well, Sanja, that proves how small the climate and especially the carbon market lawyer community is. I was on Justin's PhD committee where he was defending the thesis that became that book. And Pragit asked for the book, and I will put in the link in a moment. Yeah. I think we also sort of already answered a question that popped up while Lisa was responding about, how cryptocurrencies are involved in the carbon market, especially crediting, and what the risks are and how jurisdictions are dealing. And I would just emphasize again what I said, that it's very early. And Lisa already said, we will see regulation come, consumer protection. And just to bring in transparency, it's happening with crypto financial assets, cryptocurrencies and other things. It inevitably will also spill over to the carbon dimension of this. But I think, unless Lisa, you can flesh out and say that there's actually really draft regulation anywhere, you probably would concur that we're all trying to understand first what it's happened really quickly. No, it's not like this was very relevant just a year ago. Yeah. So in that case, I would say, let's go to another question. And while we're discussing that, I'll put the link to the book in there. Oh, thanks, Sanja. You've posted it. Fantastic. The ever-growing library of Edward Elgar's handbooks and books on climate law and policy. Two, I think, interrelated questions, and I'll pose them at the same time. Samantha Arriaga asked it to Lisa. And it was, could you please describe more about the integration of carbon and electricity markets? Because you mentioned, of course, New York ISO, the independent system operator for New York, where regulates the TSO of where I'm located and procuring or getting my electricity. You mentioned that. Can you elaborate on that? And Pragit Nibber added sort of an angle to that. So it's clearly also interesting in other parts of the world. Can you share more details about how carbon and the electricity markets are being linked? And I think he was asking that while Victor was describing this, how this was also a big issue in Mexico while the ETS was being operationalized. To all three of you, and probably starting with Lisa.
Yeah, let me start with the three layers that we've seen in terms of the linking of electricity and emission markets. First, or early on in the system, when, for example, Ontario was trying to phase out coal-fired generation before the end of its useful life. What they did in that regard for a period of years is they added an adder to the price that was bid in on coal-fired electricity generation. So it would move up in the dispatch algorithm, or move down as the case may be, would be less attractive. So it would match in the offer and bids in the electricity system later than it would if it was just the price of the generation itself. So you're altering the dispatch algorithm to provide an adder on fossil fuel emission power. That was one way. And then next, you'll remember this, Michael, when we were designing the Western Climate Initiative process, we looked at the first precursor to what was, I think, is a form of border carbon adjustment. And there were real interesting dynamics because you had California and the Western US states linking with Quebec and Ontario, which are in the eastern part of Canada. And to a lesser extent, BC is in the west. And they had to look at imports, particularly of electricity in the US. Most of the electricity in Canada is quite clean, although certainly the transport of electricity north-south is very significant. And just to put some numbers around this, the emission intensity in Quebec is about 4 grams per kilowatt hour, 4 kilograms per megawatt hour. In Ontario, it's about 36 kilograms per megawatt hour. In Michigan, it's about 738. So we're talking more than an order of magnitude, several orders of magnitude in certain instances, difference in the emission intensity of those systems. So when the electricity came across the border and wasn't subject to a carbon price, or was subject to a much, much lower carbon price, we went through this mechanism of devising the first jurisdictional deliverer obligation, which imposed effectively the price differential based on statewide emission intensity on electricity imports. It's quasi-border carbon adjustment, but to try and levelize the playing field so you didn't reduce emissions pursuant to a cap in Quebec or Ontario, only to have super high emission intensity imports come in to fill the gap at a competitive advantage effectively. Number two. Number three, the most integrated one is the New York Power Authority is looking at and was doing some work in and around actually integrating the emissions market with the electricity market. And that was kind of a macro function. And quite honestly, I think that's one of the most efficient ways to proceed. They have a lot of early work done in that regard, no firm conclusions. But if you go onto the New York Power Authority, NYPA website, I think you can find some background on the initiative of them looking at and taking submissions on. And I think FERC was open, the Federal Energy Regulatory Commission in the US was open to different approaches, but really did encourage the linking before the chair of the FERC was fired by President Trump. So.
Great, thank you. Sanya or Victor?
Yeah, I mean, just a couple of very brief points. I mean, how the energy sector relates or how it impacts, it really depends also on the constitutional framework. So if we look at the ETS, there's been interesting litigation regarding the so-called market stability reserve. So that was introduced a year ago following the price crash of carbon allowances. So the Commission basically introduced so-called market stability mechanisms, which would mean that it could bank certain allowances and in that way increase or decrease depending on the cost of carbon in the EU ETS. And then Poland took an action against the Commission's decisions, and it argued very interestingly that this specific market stability mechanism would impact on the energy sources that it used, and because it impacted that, the Commission shouldn't have taken this specific decision on market stability under so-called ordinary legislative procedures, but under special, which in the EU constitutional framework requires different kind of voting systems, and different parties are involved in the legislative process. So yes, the point here is that, again, constitutional law matters, and member states and operators have sometimes accused the EU legislator to, in fact, regulate the energy sector of the member states when they were in fact regulating the ETS. The court did not uphold that view of the Commission in that specific case, but it's interesting, again, kind of thinking about how does the energy sector, how does the ETS, how does constitutional law, how do they all interact? So they're really fascinating legal questions to unpack. Yeah.
Thanks, Sanya. And Victor, I wonder if you have anything to add.
A little bit to the part of the integration. I know that I mentioned that the electricity law helped a lot with that article, establishing the obligation for participation in a market mechanism, but it also created their own market, a renewable energy certificate program, and it created this perception of overlapping and a lot of issues for the environmental authority, because it created the perception that they were regulating the same thing, and then instruments could be interchangeable. A renewable energy certificate and an allowance, and from my point of view, there are systems pursuing different objectives, and they should operate independently, because one is clearly with an energy objective, and one with emissions under the scope, right? So I think a deeper integration should establish differentiated authorities and created more certainty for participants, because it wasn't easy to understand what the law says and what were the obligation for power generators, for example.
Fantastic. Thank you, Victor. If I may, I mean, as moderator, I should hold back, but I'll add maybe one angle, just because I happen to also have been looking into this and these complexities between electricity and emissions trading markets. The classic example is, of course, in jurisdictions that have regulated electricity prices, where you cannot pass through the carbon cost easily. And that's resulted in some, let's say, complications, but they can be overcome. And I think some of the Chinese pilot ETS show how you can do that by having essentially the electricity consumers, say buildings, commercial and industrial customers, pay for their indirect emissions. So there's a way around that. But in the EU, we have another really interesting dilemma now that goes back to the heart of how the electricity market is designed, which is sort of similar to most other, liberalized and deregulated electricity markets. So as you know, and Lisa was alluding to this, the price for electricity in the wholesale market at auction typically is determined by the marginal generator. And that's where you add the carbon price. And if it's a gas or coal, which it will be in many electricity markets, typically, at least at the margin, you will have that carbon price across all sources. Now, as you're introducing border carbon adjustments, for instance, and you're thinking about the emissions intensity of products, the emissions embedded in production of products, indirect emissions are a huge part, especially, say, non-ferrous metals like aluminum, where it can be up to 80, 90 or more %. And even if you are, say, a European aluminum smelter, and you know that your electricity is coming from a hydropower plant, which they're often co-located because precisely of that, your electricity price will still pass through the carbon price that's added to in this merit order on the stack to the marginal generator. So it might be based on a gas-fired power plant that is at the margin. So you're paying a carbon cost, but your actual aluminum may be fully carbon free. And that's one of the big sort of dilemmas right now that the EU is trying to resolve, and well, to include indirect emissions. And how do we deal with the fact that indirect emissions and the indirect carbon cost can be very different by virtue of how the electricity market is designed and how the price for electricity is determined currently. So a lot of complicated issues. I'm glad that we don't have any more questions at this point, because we're about to wrap up. I'd like to give each panelist a quick opportunity, just 10, 20 seconds. For our audience, I've often heard that it's really inaccessible, hard to sort of understand the legal aspects of emissions trading. What resources, what can I look into? Where can I learn something? If you have any tips, any recommendations that you think is a really good thing, please share it. And I'll start quickly because I happen to know I was involved in a World Bank project with ICAP on a report on governance of emissions trading systems, which has a lot of stuff on legal aspects as well, that will be launched presumably next month. So keep your eyes out for that. I think that'll be a useful resource, but there's a lot more. And I'll just go maybe in reverse order, if that's okay. Victor, do you have any sort of thoughts, anything that helped you when you were working on this at Semarnat or now at South Pole?
Definitely. I'm an engineer myself, but I had the chance to learn a lot from lawyers like you, and I think it's something that you cannot leave behind till the end. You can have the most beautiful designed system in your head, but you have to also be realistic in what can be done legally speaking in your own jurisdiction. So take the time to always speak to a good lawyer. Take the time to put things in a paper and discuss with a lawyer what can be done, and then learn and be patient when you're explaining to a lawyer that it's not knowledgeable of this kind of instruments. Because I had a really good experience working with pretty good lawyers in Mexico back then, and right now as well when providing counseling to our clients.
Thanks, Victor. Sanya, any thoughts from your side?
Yeah, so I do think that the legal landscape has changed. So when I started researching 2000, shortly after 2005, there was absolutely the legal debate was almost non-existent on ETS, and I think that has changed. There is definitely in both a scholarly community and practitioners, and I think the field is exciting and has changed in that way. Where to start? I would always say, and this is what I always tell my students, I would start with the law. The European Commission does have, if you're looking at the ETS, and I know the many jurisdictions do take inspiration from the ETS, I would go to the Commission's website for climate action. And there are many directives, but there are also really fascinating communications from the Commission, and one can follow the legislative developments. So I would look at, well, what does the law actually say? And how is it structured, and how is it set out, and how has it been developed over time?
Thank you, Sanja. And Lisa, I hope I'm not causing you trouble with the next meeting I'm sure you're having. Any final words from your side?
Yes, a few. First of all, Michael is the chief editor of the Climate Change Law Review. It's a great source. And from that perspective, I think I would refer you to that. The second is the International Emissions Trading Association has a legal working group, and a lot of the information is available on the public website, but also membership and getting involved in that legal working group is really a good source. We are coming out with a series of draft contracts that are coming forward. And then third, I'm just going to put it in the chat here. We, Resilient LLP, a little climate boutique that serves many global interests, do a bulletin that is free of charge. And if you want to get on it, I'm just going to put Monica's email here. Just give her an email and say, please include us in the bulletin. And a lot of people seem to like that one. So
Thanks.
There you go.
I have to subscribe to that. Thanks for pointing it out. I didn't know about it. It's great. No, not at all. Thanks. And thanks for the shout out. I should mention you've been on the board since the inception of the Carbon and Climate Law Review as well. So there is a common history there too. So our time is up. I could do this, I think, all day. This is a rare opportunity to discuss with like-minded, legal experts or those who have worked on the law, but we have to close. I'd first like to start, of course, by thanking our panelists. I mean, thanks for sharing your knowledge, for taking time and really enabling an excellent discussion. So broad, covering so many different aspects. And I really think the audience got a lot out of that. Of course, thanks to the European Commission for supporting the webinar series and ICAP for hosting it, and to colleagues behind the scenes who've been helping set it up, and of course to the audience for great questions. There will be a next webinar installment, of course, and this one will be exciting too, I think. It'll discuss the outcome of COP26 in Glasgow, and specifically the CMA decisions operationalizing Article 6.2 and 6.4 of the Paris Agreement, and the relevance of that for domestic emissions trading systems, since that's our focus always. We'll announce further details on that in coming weeks, and you can always, so through our usual newsletter, you can also visit the website. Johnny posted it in the chat, and there you can also register for the webinars. And with that, sadly, we have to come to a close. Thank you, everybody, and I look forward to resuming the discussion many different ways. Stay safe, stay well, see you soon. Bye-bye.